When you're working on an M&A deal, it's very important to have a good understanding of the overall deal process and its typical stages so you know what to expect and when. Obviously, every deal is different, but we're going to describe a general model that reflects the stages most deals have. The first stage involves the buyer and seller assembling their deal teams. It's worth pointing out that when a deal comes into a law firm, the business team, which usually includes the general counsel of the client, has likely been working on the deal for a while. This means that many of the terms will have already been agreed, and there will be an urgency to get the deal done. The deal team is made up of representatives from the clients, of course, as well as from the banks, law firms, accounting firms, and other organizations involved with the transaction. Once the team is in place, one of the first documents created is the working group list, the document that lists the names and contact information of the organizations and people working on the deal. It will be updated throughout the course of the transaction. The next stage involves initial deal documents. Parties typically want to agree on the most significant deal terms before spending too much time and money negotiating the full purchase agreement. These terms are usually included in a term sheet or letter of intent. There will also be agreements to protect confidential information, hire advisors, agree whether the seller can keep talking to other potential buyers, and other preliminary issues. Common agreements covering these matters include confidentiality, engagement, indemnification, and standstill agreements. During this initial deal document stage, and even earlier, it's common for the parties to be working on the due diligence review. Due diligence is an information gathering and review process and a critical part of any deal. It lasts from deal kickoff to closing, although most of the work takes place early in the process. Diligence is often broken down into legal, financial, and business reviews. Due diligence helps the parties learn about each other's business. It also has a significant impact on a deal, influencing things like structure and price, negotiations on deal documents, required approvals, timing, and closing. Facts uncovered during a diligence review can even impact whether a deal goes forward at all. The attorneys usually manage the process and have different roles depending on which side they represent. Buyer's counsel creates the due diligence request list, which is an extensive list of what the buyer wants to know about the seller. With the help of the deal team, they then review and analyze all responses and documents, follow up on open issues to understand the business and legal risks involved, and make sure there are no surprises. Seller's counsel works with the business team to populate the data room, which is the place where all information about the seller is stored. They also oversee the process and respond to inquiries throughout the deal. Data rooms are almost always virtual these days, meaning all documents are uploaded to a secure website. Diligence reviews by buyers are usually much more extensive than reviews by sellers because it's the buyers that will own the newly acquired assets or equity after the closing. That said, sellers still do some level of review based on several factors, such as the type of consideration received and the structure of the deal. The diligence review typically results in a due diligence memo drafted by the buyer's counsel, which summarizes key findings about the seller. As we mentioned earlier, these findings are very important and impact various aspects of a deal. The next stage is drafting and negotiating the main documents. The most significant document is the purchase agreement, such as the stock purchase agreement, asset acquisition agreement, or merger agreement, depending on the deal structure. Around this time, negotiations also begin on other key documents, also known as ancillary agreements, like loan or financing arrangements, executive employment agreements, and shareholder agreements. The list of required ancillary agreements is deal-specific and often spelled out in the main purchase agreement. Once the deal documents are finalized, the next stage is signing and closing. Signing is just that. The parties sign the documents and create binding obligations. There are two types of closing, simultaneous and delayed. A simultaneous closing is when a deal signs and closes on the same day, and a delayed closing is when a deal is signed on one day and then closes on a later date. The reasons for simultaneous versus delayed closings vary, but are usually related to regulatory filing requirements or commercial considerations. Specific closing requirements are defined in the main agreement, usually in the closing section. Generally, closing is when the purchase price is paid, the assets or ownership interests are transferred, and the necessary certificates are filed. Before the closing, the parties usually have a pre-closing. This is where they sign the final deal documents and exchange signature papers, and then counsel for each side holds them in escrow to be released at the closing. This is done to make sure the actual closing goes as smoothly as possible. The closing also includes specific closing documents known as officers' and secretaries' certificates. These documents confirm that a party has done what it needs to do to close the deal, including fulfilling its obligations under the main purchase agreement. The parties start getting ready for the closing at deal kickoff by preparing a closing checklist, which is basically a to-do list for the deal, taken from common practice and the closing conditions section of the main purchase agreement. The last stage of the process is the post-closing. Even though the deal has closed, there are usually some things left to do, such as making regulatory filings, getting any consents that weren't required for the closing, and other obligations. A law firm associate typically puts all of the deal documents together and then distributes copies to the team. These are referred to as the closing sets or closing binders. They're used to quickly refer to deal documents when needed and as models for future deals. These are the books and binders you see in any corporate lawyer's office.